Okay, welcome. This is Remedies. We have not a fair amount of work to do over the course of the semester, but you guys should have found the syllabus online. There's some outside my office. But the schedule over the next 15 weeks, you'll find the material online. We're going to be in class together, but there will be people online listening to the classes as well. But if you look at the schedule, you have readings for each of the weeks, in some cases individual classes. We'll have a discussion of those. What I've tried to do in selecting the materials is look at remedies really from a more modern concept. Remedies historically really is taught and was looked at as equitable remedies, injunctions, specific performance, things of that the court of equity historically would have looked at. But the fact is, when we start to think about modern remedies, there's as many statutory rights that you should be aware of and remedies for wrongs done in that fashion, as well as there's an awful lot of significant damage issues that we have to start to think about moving from law student to lawyer, because a lot of these problems that we're going to look at over the course of the 15 weeks problems that the clients will come in with, and the question is, when they come in, they don't have contracts question on their forehead or torts or property. They have a problem and they expect you to use all your various courses and all your various tools at your disposal with respect to evidence, knowledge, and damage issues to get them what they're seeking. So to a large extent now, we're going to look at these problems from a 360-degree perspective as if we were lawyers and try to figure out, well, how do we move them from what the client is looking for to a proper resolution. So we focus on a lot on trying to solve the client's problems and the like, and really taking a look at a lot of very common issues that occur in our law practice and how you're going to deal with them. We spend a fair amount of time on looking at injunctive relief a lot more closely with respect to that process as to how that's engaged in and under what circumstances you should be asking for some of the safeguards, the procedural safeguards in place there. But we also look at some of the damage issues, because I know you all sort of have the basic understanding that damages are designed to make the plaintiff whole, but how do we put a proper number on a given case, and how do we then find and admit the appropriate evidence to persuade the trier of fact as to what those damages are? Because there's a million different ways to calculate damages and to offer proof on those damages, so we're going to look at that a little more carefully as well. There's a lot of these cases as you look at as we go through them that will raise some, I hope, some ethical and moral issues that you're going to have to deal with and that we'll talk about, so that you want to think about these cases from that standpoint as well, because most of you are, well, you're all, I think, pretty near the end of the process, much closer to the end than the beginning at this point. And so now we have to start to make that transition from law student to lawyer, and how do we deal with a lot of the issues that are raised with these cases. So I hope you start to give them a little more thought as we go through them as well. But a lot of CivPro, a lot of remedies, jumps off from where we last met in CivPro, because all of that stuff is a given, subject matter jurisdiction, personal jurisdiction, venue, where we go, why we go certain places. But that's sort of the real base level here that you've got to reacquaint yourself with. So one thing you have got to do, and what I've done is I've put it on the list for this Thursday, is you've got to go back over your 103 CivPro and remedies questions. But what I'm going to suggest to you is, and I have some of them here, and there'll be the 103 questions are online as well, but they are in the process of redoing the audio. So while it is listed for Thursday's class, you don't have to do it on Thursday. And while if the new audio is ready with the PowerPoint by Thursday, great, but I'm sure it'll be ready by the following week. So what I would suggest you do is not rush through it. And I don't feel you have to do it this Thursday, because the new audio has a different section on personal jurisdiction, which has changed or it's gotten modified since some of you took it. But also the significant change that we've seen now is with respect to discovery as well. So that is a little different than it's been. So there's a couple of sections that are different than the prior PowerPoint, and I might wait a week to make sure you're working with the new one. Questions there's some that are slightly different, but again, I'd rather have you work with the more recent one. Because you've got a few concepts that you need to think a little harder about than before. So there is no class on Thursday. I have to go to the trial competition. The next time we meet will be a week from today. You have the materials. All of these materials are on the CD, either in the bookstore, or if you got the CD when we did Civ Pro originally, it's already contained on that CD. I think you might need a code to unlock it or whatever, but you can email Dan Hrader at mslaw.edu and he'll provide you that information. But everyone needs to get the packet of materials which are contained on the CD. You've got case citations and the like if you want to try and grab them, but there's a lot of articles that are in there as well, and so it's just easier to find them all together. And that's the thing with respect to the cases and assignments that you're going to see for each week or each section, is that there aren't necessarily tons of cases, but there are a few very important cases that are unedited, like happens in the real world, so you need to look at them and figure out what parts are important. But also there's a fair number of articles that really address some of those issues. They're not cases. But again, as lawyers, we get a lot more information oftentimes from articles and other sources than just, we don't sit there day after day reading cases upon cases. And so I'd read the articles carefully as well. But you need to, in order to be prepared for the class, have read the materials. Oftentimes, for any given section of class, I'll make reference to a specific rule. So for instance, next Monday it says Federal Rule Civil Procedure 65. You need a rule book, or you need to have printed out the rules, which are free online, so that you can look at it, because what we're going to do is look at these rules a lot more deeply than when we did Civ Pro initially, because in a Civ Pro, which is at least from the standpoint of that case proceeding from beginning to end, is a rule-based instruction, and if you don't follow the rules in court, in the real world, they're not even going to entertain whatever pleading you're asking or whatever motion you need addressed, because you've failed to conform to what the rule requires. If you don't do something timely within the restrictions on the rule, you might as well have thrown away that paper instead of filing it in court. So we're going to take a careful look at some of these rules so that we can think about them a little more in depth than when we looked at them in Civ Pro. So if you go through the syllabus, you'll see what we need to do. We have a midterm examination. We also have a final examination. Whether you're taking the exam, whether you're taking the class online or in person, everyone will have a final examination of 3 hours in length come May during the regular exams, and we'll take them in person. You should look at the old exams to get a handle as to what we're looking at. We don't reinvent the wheel. A lot of these topics, many of the topics are centuries old. Others are of more recent vintage, but not more recent that you wouldn't have an understanding and familiarity with them, and looking at the old exams can help. Students who are taking the course online will listen to the audio each week, and then there are questions posted each week for the students to answer, and they will answer them and respond to them by email. They should be submitted timely, and timely means within a week to 10 days of the audio for the class for that section having been posted. So it's not a good idea to wait till the end of the semester or the middle of the semester, because all of them are due at the midpoint, the ones up to then. And the fact is, you don't want to fall behind. And the same thing for you folks taking the class in person. You don't want to fall behind, because then you won't have a good understanding of what we're discussing and what those issues that are involved in that case entail. But the final exam is in May. Everyone's going to take it. And if you look at the old exams, you'll have some understanding of what it's likely, the format is likely to look like. A couple, did you have a question, Ray?
Yes.
Go ahead.
For the in-person, in-class students, if we miss a day, can we listen to the online audio and answer those questions as well?
You can, but you guys are, yes, but because you've signed up for in-person, you're expected to attend class. But yeah, if you've got a doctor's appointment or occasionally sick or whatever, the audio is there. Some people will listen, will choose to listen to it anyway. But then submit the answers to the questions. And the answers to the questions themselves, and the answers to the questions as you start to think about them, are not a bad way to start to think about preparing as well, because those questions, those topics, those issues will reflect oftentimes what we've discussed in class. But they also are likely to be some of the highlights of those cases and the issues that are raised by those cases. So it's not a bad thing to look at. And you can think about this. What I've said in other years is, for the in-class students, if you decide you would rather submit the answers to all the online questions at the midpoint instead of sitting down and taking the exam, that is an alternative I've given to students who are taking the class in person before. I don't need an answer today. We can talk about it as we get closer to exam time. The exam is the last Thursday before your break in March, but we don't need to decide that today. You can think about it, and whoever wants to take the exam, we will do that as well. So you don't have to. That's an open issue for now. You don't have to think about what you're going to do just yet, because we've got at least 7 weeks till we get there at any rate. Do you have other questions so far? I think it's important, and see, you guys aren't covered by a lot of this, but specifically for the online students that are listening to this, what they've got to do is make sure they have read the materials, then listen to the audio of the class, and then respond to those questions in a timely fashion. And then remember that regardless of whether it's online or in person, we all take the same exam. Everyone is expected to obviously meet the same standard of knowledge come May, when the examinations are offered. Okay? If you look at the end of the syllabus, what I've asked you all to do online, or for those sitting here, is that I would like you to email me your list of 3 fundamental things someone should know about the area of law you intend to enter, or about the field in which you presently work if you intend to use your law degree in that capacity. So I would expect that at this point you've probably given some idea to what type of law you might like to practice, what areas interest you. I'd like you to take the next step now and think about, well, what if I were to be whatever type of lawyer you're thinking that you would like to engage in or be considered an expert in, or just practice law in, but hopefully do a really good job in that area. What do you think the 3 fundamental things that a lawyer in that area should know, or should be cognizant of and keep in the forefront of their mind? And if you're thinking, well, I haven't really thought about that to the extent that I know what I want to do, a lot of times people don't necessarily know exactly what area of law they want to do while in law school. But you should start to think about 3 fundamental things that any lawyer, since you're going to be lawyers soon, hopefully, should be cognizant of and should try to pursue so that they become excellent lawyers. And if you intend to use it in HR or wherever you may presently work, law enforcement or whatever, I'd like you to think about, well, so what do I need to know there with respect to 3 fundamental things? I'm a big believer that things, boil down to essentials at some point, no matter what it is we do. And instead of trying to figure out 20 different things I got to be doing every day, if we can focus on a smaller number of things, 3, we can remember those, and they can dominate our thoughts and actually drive us to a higher level. So I'd like you to give it a little thought, everyone to give it a little thought, and really tell me what you think those 3 things are. The question says, how will you ensure that as a lawyer you will always represent clients at a very high skill level? And that's not just giving me some abstract BS, because again, part of the idea with this course is to move from law student to your transition to lawyer. So how do you think that works? What is it you intend to do once you leave here? Is it just leave here, pass the bar, and whew, now I get to go represent clients? Well, how are you going to do it at a high level? What do you think the essence of that is? And how are you going to keep that edge? What do you intend to do as you practice law over the years? There's an old expression, I think it is true, that the day you leave law school, you'll know more law than you will ever know again. And that's in part because, it's a lot of survey information, right? And at some point, not necessarily right away, but at some point you tend to gravitate to 1 or 2 or 3 areas more than others. And so how do you keep that knowledge? Not all of it. I mean, I haven't done family law in 20 years and have 0 interest in ever doing it again. So I don't really care what happens in that area, but I do care about litigation. I do care about evidence, obviously. There are things that I care about and need to keep abreast of and need to, hopefully, practice at a high level. There are things you need to do in order to do that. So what is it you're thinking of? How are you going to keep your edge? Right? How are you going to keep your knowledge current? How are you going to keep your representation of clients at an extremely high level? And I just want you to think about what are the fundamentals about what it is you intend to do, and I'd like you to email me that information. Doesn't need to be this week, but I would like to see it relatively soon so I know who's here and what they're doing and what they intend to do, because that's a significant part of this course, is for you to think about how all of this stuff that we're going to be looking at what it means with respect to the actual practice of law, and how do I help my transition from law student to lawyer, and then once I'm there, how do I keep performing at a relatively high level? So that's, everyone should do that within, say, not this week, but by the end of next week, have made sure that you've emailed me that information. Let's talk a little bit about the first stuff you should have taken a look at, and I just want to talk about it briefly. So I told you that at least CivPro, the jumping off point for remedies is CivPro. So you want to go back over that information. You've got the 103 questions to answer and submit. But I'd go back and take a look at the chart on procedure, really think about some of those concepts with what you now know, and recognize that this is how all of our cases start. We've got to figure out what court to go to, and that's not just federal or state, and you know those options. But then, am I going to go to Massachusetts or some other courts of a different state, and why? And you know, those oftentimes become very real choices, and they're important choices because to the extent that you are able to get your case to trial fastest, if you're the plaintiff, that is part of our objective as a lawyer. You know, the fact is that it's far too common. The defendant sees their function as slowing it down, trying to put as many procedural roadblocks in your way as possible. I've said to you before, every day they keep $1 in their pocket, that's a victory for them. And if I want the case to settle or try it, whatever I want, the way in which that, as much as I can preach ADR to you and mediation and conciliation and all the rest, civil cases are still likely going to settle closer to the end, very close to the end, than the beginning, until people feel pressure. Unfortunately, oftentimes it's very hard to bring people to the table and really get them to sharpen their minds and think about what the loss actually looks like. So that becomes a big consideration. Where is it likely I can get the maximum return for my client in the shortest possible time, if you're the plaintiff? Now, the defendant doesn't have a choice on where the case is entered, but the defendant, and you remember, has some choices on whether the case stays there, removal jurisdiction, or whether we seek to transfer it to a more distant forum on a forum non-convenience and the like. So I want you to think a little more about those, not just that they're there, but how can we use the rules and use the process to advantage our clients. And that really starts with making sure that we understand what the various choices are, what goes into those choices, and what we think we should be pursuing under the circumstances. And we've almost finished one where the choices were federal or state court, Massachusetts or Connecticut, and it really, the abstract notion of SPV and all the rest of it becomes important because the client doesn't care about all of those things. They don't oftentimes know, but what they do know is they want a resolution sooner rather than later. And the defendant oftentimes wants it never, much less later rather than sooner. So I need you to think about that, look at the chart, start to think about some of those issues again. And then I want to talk a little bit, because we're not going to have a long class, but I do want you to look at those articles. You have lawyer turns peacemaker, and then the 7 steps to effective mediation and settling the score. Let me say something about the first half of this. I do believe that we should use mediation, conciliation. We should always be open to try and resolve and negotiate cases because it's in everyone's best interest to keep that open dialogue. And, as a case moves forward, the fortunes go up and down like this. Some days are better for you as the plaintiff, and some days are better for you as the defendant. But all of that length of a case and the ups and downs gives you an opportunity to have a dialogue with the other lawyer and to try and recognize that while fortunes may change, we still should be having a discussion about where we stand and what this case is likely worth. But let's be realistic. I might like to settle at the top of that curve because I'm in pretty good stead today. But you'd almost be a fool to want to negotiate with me at that point because my number's higher. Now, you might like to negotiate down here, but I've got to be cautious, and especially as a new lawyer, I've seen sometimes we think that, oh shit, this case is in deep, deep trouble. Better settle now. But if you settle at the bottom, you're shortchanging yourself and likely your client because it doesn't just go up and down. I can tell you, having practiced law for a long time, it goes like this. It's much more like an ocean. There'll be another day, and so what you need to do is see it as an opportunity, but recognize there's a value to this case no matter what. And so what you have to keep in mind is, well, what do I think a reasonable solution on the case would be? What is the value that it makes sense to walk away as we talk about being a peacemaker and not just using litigation to bully and push the other side around? Even as I say that, though, I have to be real about it, is that too often in civil litigation, you have to use the process not to bully, but to keep advancing your client's interest. And part of it is I'm coming off one right now, and the other lawyer's still a jerk, where it just pushes you to say, you know, if we didn't have a trial date, that case still wouldn't settle because they want to keep every dollar in their pocket and they want to know that you're prepared to try it. So I can tell you to try and talk reasonably, to be kind and cooperative with the other side, but at the end of the day, it takes two to agree to do that. And so I'm always willing to talk, but also realistically, there's a value of to this case, and what I expect to get through discovery, what I expect to find down the line, what I think I can prove. And part of that means that we have to understand the rules of evidence. We have to understand how trials work. We have to understand what the law is on the underlying contract claim or tort claim or whatever it is, and not just understand sort of the abstract notion of how it works. But now we got to take a hard look at it. Is okay, the contract law says X. What is my evidence of X? And is it going to be admissible? Am I going to be able to get it in? And then is it going to be persuasive to the jury? So you've got to take sort of this abstract notion and start to move it down the road to really be able to properly assess your case. As you think about that, you know, let's suppose, as we think about the value of a case, let's suppose you've got a contract action. If everything goes well, you think your evidence is pretty solid. If everything goes well, all the evidence gets in as you'd like it, the jury accepts it for what you think, then your damages appear to be $2 million. That's what it looks like. But let's suppose that, I mean, if I asked you, well, what do you think the chances of establishing liability are? What do you think? Just give me a number, I don't care. I assume it's got to be greater than 50 or you wouldn't you likely would have settled a long time ago. So you've got to think that you've got a better chance of winning than losing, I would expect. So what do you want to give me a number? 60?
75%.
75%. Okay, Jace wants to go. He thinks he's got a 75% chance of winning. And at best case, your damages are $2 million? That's what we said, best case. So what is it at likely case? If the best case is $2 million, what is it likely case in your evaluation that number's going to come in at?
1.75. 1.5 million.
Okay, $1.5 million. I was going to say 1.75. You're really a little ambitious here. A little.
I say 750,000.
Okay, so we've got two numbers. One at 750, one at 1.5. Now, so this is the question. This is the way okay, so now my question is, for both of you, because you gave us numbers. So what do you want to settle the case?
1.25, I'd settle it.
Okay, so we'll come back to that in a minute. What do you want? $500,000. Okay. Now, first of all, he might have a deal, but I don't think you do. I know you don't. Okay. You said you think the likely case is $1.5 million damages. Top damages are $2 million. But you think, and it sounded optimistic, but I'm going to go with what you said, you have a 75% chance of winning, right? So 75% chance of winning the million is on $1 million is 750,000. 75% chance of winning 500,000, because that's all you got left, is what's that? 3/4. So what's that? 375? Yeah, 375. So that's $1,075,000 should be your top number, no? Just doing it mathematically, if you've got a 75% chance of winning $1.5 million, then if you want to have a discussion, at least as you see it, a fair number for him is just a little over $1 million. So if you're telling me $1,250,000, I don't think we have a discussion. Raymond thinks it's a reasonable number on that, of what the jury is likely to come in at $750,000. 75%, so 3/4 of 750 is, well, no, maybe we don't have, oh, and you said you'd take 5.
I'll take 5.
Okay, so 5, that's only 2/3. That's probably sounds like a pretty good deal for me. Doesn't it, as if I'm the defendant? Like his top number is $2 million. He thinks, well, you guys are thinking, I'll just accept it for a given, that the chances of establishing liability are 75%, and he's willing to take only, not that writing that check out is easy for anyone, 5. We certainly have an avenue to talk, and maybe talk early. And here's the thing that's important. It's always important to me, but it astounds me how defendants, I just don't see it like we should. If Raymond and I have a discussion, and ultimately I get them to 4. And I don't represent defendants, but if I'm representing a defendant, 400 on his top number being 2, right? And I'm the client, and I get to save what is likely $100,000 plus in attorney's fees, because if we go further, that at the minimum that money's spent, that's lost. If you take 4, that's not a bad. That's certainly worth discussing, and I'd discuss it with you, but I don't think realistically it's going to go anywhere. The point of the exercise is part of us have to evaluate the case properly as to what we think. And all of that, we can put math to it, but there's still no certainty, right? There's no certainty to say, well, I guess I do think there's probably certainty to what you think that top verdict is likely to be, right? Because I can look at what, we just had this problematic contract case. And the question was, well, what are the damages? And there were different ways to value the damages in the case. But the top number, and I can tell you, I could say to the other side it's a lot higher than it was, but the top number is probably $1.3 million. I can tell you it's 2, but 2 would take a miracle. I mean, 2 would be very difficult. So, but I think the top number, about $1.3 million, would have been fair, and I could see that. The case had some liability issues. The case had some damage issues. Not all the evidence necessarily comes in. So all of that goes into trying to think about what the value of that case is. And part of it is, though, too, defendants, we talk about be a peacemaker, and I want to talk about a couple things one of the lawyers said, because they're important, but they're hard in practice, is that we shouldn't take it personally, but we should have a dialogue, and what we should do is really keep the clients informed, because at the end of the day, it's their money that we're spending. And especially, in any piece of litigation, but especially when the stakes are higher, it's very easy to roll off a bunch of depositions and a bunch of documents back and forth and all the rest, and spin our wheels on a lot of discovery and cha-ching, cha-ching, cha-ching at $300 to $500 an hour. But at the end of the day, the client's better served by that, or is there a number sooner rather than later that we should be looking at? And I think it's important to keep it in mind and to try to be honest about having that discussion. But at the end of the day, if you're not going to be realistic about your chances, or you think somehow you can bully and bluster your way past all this, and in a lot of civil cases, what they want to do is know that they defeated you at summary judgment, and a lot of people aren't willing to walk away before they do, not walk away, but settle before they do, that in order to take a case all the way from the beginning, all the way through summary judgment, that's a lot of cases, that's at least tens of thousands of dollars, and in some cases going to be over $100,000. I argue, but again, I'm a plaintiff's lawyer, I argue that if you put that money into the case at the outset as a settlement offer, you might be better off, because that means you get another $100,000 that certainly is going to interest me in trying to help to achieve a settlement. But that's not always the thinking. It's oftentimes not the thinking on the other side. A lot of times they're going to try and wear you down. They're going to try and see if your client is going to invest the type of money needed to pursue the case. Or whether you'll grow tired or weary of it or run out of money and walk away. So especially larger defendants have a tendency to do that, because they have more resources and time, and the lawyers tend to be big firm lawyers who have a lot of billable hours they got to churn out. We all do. And so it becomes a bigger problem. with recognizing the client's interests come first. And so you've got to be prepared, and your client needs to be prepared to pursue it for the long haul, even if you have an interest in settling, your client has an interest in settling. If the other side isn't being realistic, it's not going to happen. I'm of the opinion that two lawyers who have some level of experience and knowledge, both from the standpoint of practicing law and the process itself, they should be able to realistically assess the value of the case. Sometimes before discovery, that's going to be harder, but that's one of the bigger changes under the federal rules of evidence that's in effect now, is in federal court, the court has the power to restrict your access to information to a much greater extent than before. The new language in the scope of discovery is the word proportional. And so in federal court, that gives the court a lot of latitude to sort of shrink the material that you might have otherwise been able to get, because they, at least in part, the federal court now has the power to regulate discovery so that it reflects the value of the case. And I'm troubled by that, because the value of the case really depends on not necessarily a federal judge's perspective, who likely has plenty of money and power already, but if someone has lost their job through illegal discrimination or whatever, this is a pretty valuable case to them. And the fact is, if Fidelity has the documents that I need in order to prove my case, the fact that Fidelity comes into court and says how burdensome and onerous it is, and this case isn't worth that much because it's only a year's salary or whatever at a relatively modest amount, to Fidelity that the value of that case is next to nothing, to the injured plaintiff that the value of that case is high. And that's a worry that the federal court now, with the new language in the rules, proportional, that the discovery should be proportional to the case, that is going to see a shrinking of the available information that we have access to. And that's oftentimes the way a defendant in a civil litigation engages in the litigation, is to the extent I keep information from you, the plaintiff, who has the burden of proof, then has the harder time proving their case. And especially, defendants fight even harder when the stuff I've got to turn over is really good for you. So that's what's kind of interesting about it. The harder they fight about giving you access to it, the more you know you need to get access to it and how important it is. And so that engaging in protracted discovery battles like that runs up the money quickly. But you don't have a choice but to do that, because oftentimes those smoking guns are found in emails and text messages and things like that. And sometimes they're going to try and dump them on privilege logs so you have harder access to them. I would hope more of you will decide to play fair and fight by the rules, but I also recognize that we don't practice law by ourselves. We practice against adversaries, and so we've got to keep them on. We've got to keep everyone honest, as much as we might like to think about resolving the case. I want to ask you, I've got to find it quickly, one of the lawyers. Yep, go ahead, Ray.
Now, just to go back on what you're talking about, from an ethical standpoint now,
Yep.
Say if it's a wrongful death case,
Yep.
and you're a plaintiff lawyer, you've done funded the case,
Yeah.
but you have some difficult clients, and your clients are really in the case more for principle than the monetary gain. How do you handle that? How do you handle it?
That's a really good question. I mean, listen, if as long as people understand what the cost is, and that they're willing to pursue it and underwrite it, and understand that I use this expression a lot, you want to be careful that they understand that they may be throwing good money after bad, right? There's already a loss here. You may never see a return on some of this money. And principle is one thing. And especially for businesses. A lot of times businesses, but they have lots of resources. So but oftentimes businesses, it's a business decision, so principles don't matter. But let's assume that they want to, and some will defend cases. Their principle is scorched earth. If we settle this one, then everyone else will come out of the woodwork and they'll sue us too. If people know that our history, like the president, when he was a private party, the Trump organization would not settle anything. You took it to trial, and even if you took it to trial, they'd take an appeal. That was the history. So there were a lot of vendors, a lot of people just said, this isn't worth it, right? There were people even at Trump U who said, you know what, I don't want any part of this. You know, even though they had legitimate legal claims. Because the principle was, we will never settle. And there are a lot of companies like that. We don't settle anything. You win, you're going to win at trial. But realistically, if we're taking a case, any case, to trial with some level of discovery, it's easily, you're likely going to spend north of $100,000 plus. Easy. Even, you know, not even a complex, but a divorce case now with custody of kids and a fair amount of resources, you're going to spend north of $100,000 as a client pursuing that aggressively. So again, and that's where sometimes the principles come in, the custody, and especially all of the assets that we've acquired over our life. And the problem is sometimes the personal part of that affects the business sense of at least the distribution of assets part of that. I think how you handle that is you really have a hard conversation with the client so that they clearly understand what they're likely to spend and going to spend, and that the result may not be satisfactory to them. Because here's the problem. You need to do that. Because let's suppose you don't do that. And then we're in 150 grand or 200 grand. And the result's not satisfactory. If you didn't do that, then you got to complain to the BBO. Now, even if you did it, you might be getting a complaint to the BBO. So that's the other part about law student to lawyer. I'm not just going to talk to you about it, I'm going to send you a letter. I'm going to have a letter in the file so that you clearly understand. You are risking money. The likelihood is you will never see back that this really doesn't necessarily make sense. I'll pursue it because you have a legitimate claim, but you're spending likely more, you're investing more in this case than you are likely ever to see a return, and you may not like the result no matter what. And that's not just a conversation we have to have. That's likely I'm going to submit it in writing in a CYA letter so that later on down the road it is clear. Not only did I tell you, I stressed how important it was by following it up in writing. Because you guys are always the first person that goes under the bus. Okay? You're my lawyer. You're not my friend. You're not my family member. So, you tell me to lie, and I get caught, you're going under the bus. You tell me, you take too much money from me, promising me things. I think I've told you this, but I used to work with a lawyer. He was an incredible rainmaker. What that means is he could get clients. He could walk into a bar and come out with a handful of clients. And not just clients, but big deposits, big retainers. And we were both young lawyers at the time. And part of I know how he did it, because he would promise them anything. Whatever they wanted, he would promise them that he could get it. And so they'd give him a check. And then it would go to shit sooner or later. After spending a lot of money, having even more than they originally put up. And then they would be screaming, holy hell. And he used to come, Mike, I don't know what's going wrong with this case. Clients are crazy, they're going to complain to the BBO. I said, what don't you know went wrong with this case? I said, you promised them everything. You've been pouring gasoline on this case for 18 months, and now it explodes, and you're surprised. I said, this is no surprise based on what you've done over 18 months. And now, he's beside himself because now he's got a problem. Well, he's got a problem that's self-created. And the hardest thing we do is to give clients news they don't want to hear. Even this, they want $1 million. Well, you know what? We might get it at trial, but the likelihood of that million is pretty low. We want the $1.5 million. Or what we say, 2 million. We said the top number's 2. I want 2 and I won't take a penny less. Well, that's just damn foolish. Because that requires every piece of evidence to go in, first of all, with nothing excluded. It requires the jury to accept you as a good witness and like you, because, you know, we can talk about the law, we can talk about everything else, but if they don't like you or your client, they don't have to do anything. I had a jury in Philadelphia tell me one time, because I did the post-jury discussion with the jurors. They said, we were hoping you had a good case, because we really didn't like those other lawyers, and we were hoping we didn't have to fine for them. They of course they do. If they don't like you, why? Because cases that get tried are generally relatively close, because if they're not, if you know you got a winner, and they should know that, then that case should settle. If you know you got a loser, and they know that, then that case should settle. It's the ones that are close that are the only ones that really should get tried. And even if they're ones that are close, like I said to you, and when we did the mathematical formulation, let's say it's a 50% chance of getting $1 million, just to make the math easiest. But $1 million there's only a 50% chance of getting $1 million. Well, that means we should be settling for 25 cents on the dollar, right? That case is worth 250 grand, because you only have a 50% chance of winning and a 50% chance of getting $1 million. Well, that's 225. That knocks it down to 25% chance of $1 million. That's 250 grand, and you may not even get 250, but that's a fair number for that case. You know. Now, is there an upside? Yeah. But now you tell your client, they say, no, I want $1 million. Well, the likelihood of that is pretty remote. And so now we have to have a discussion that they don't want to hear. And part of the problem is that your loyalty is to the client, but you also, in that vein, you have an obligation to be honest with them. And just make sure they understand the risk. Because at the end of the day, you're going to go home and sleep in the same bed. Now, civil cases, if you're a contingent fee, well, you might sleep a little bit better on your mattress full of money, but it's still their call at the end of the day, and you've got to be careful of that, that they've made an informed decision. But that's a difficult conversation. Well, this is a lot less than I expected. Yeah, maybe, but, you know, deposition didn't go that well, and people don't always self-assess well. The evidence jury could see it one way, jury could see it another way, and then that's the last part of it, right? I don't know I'm getting the jury I want. I mean, when you say, 50% of liability, 50% of the $1 million, part of it depends on who I end up putting in the box. A lot of juries now, you're talking about groups of 6, 2 alternates, 6 jurors. Only takes a couple to make that case that was a good liability verdict be a no liability verdict. So that has to go into this as you think about it. We're going to talk about that, but I know, and I can tell you that alternative dispute resolution is absolutely a good thing. Settled a lot of cases, not a lot, some cases with the use of ADR. In my experience, unfortunately, closer to trial date than closer to the beginning. And that's because, in my experience, until sometimes clients need to hear from the judge or the decision makers. Sometimes they need to spend some money and time seeing how the process works. Sometimes it just takes a length of time to get over some of the emotional baggage that comes with some of these cases. Even this business dispute we just had. The feelings were hard. Certainly my client's side were hard. He felt the company was cheated, and they were. But you got to get past that, and at some point look at it from a business perspective. I just want to find out, this lawyer as a peacemaker, here it is. and I don't know, this was one of the early articles, but I just want to, it's on page 501 of Lawyer as a Peacemaker. And what they suggest here, and I think there's some good suggestions, because part of this is unique, and part of what they're suggesting here is to really, I'm sorry?
The page you said.
This, in my book, it's just the article which was at the outset. I'm not sure it's in your package, but it's Lawyer as a Peacemaker, and it's page 501 of that article, but this might be, this is by Forrest Moston. It was from Family Law Quarterly. I don't know whether you got it in the package or whether you were supposed to pull it off online. But I just want to say what he says here, at least some of the things he's just suggesting to you. Always try to be courteous and cooperative and polite with the other side. Right? There's no reason why we should engage in personal attacks, why we can't agree to accommodate your kid's medical appointments, or what's he say here? Readily agree to requests for personal accommodations from the other party and counsel for continuances based on illness, children's needs, work responsibility, and other reasons. Now, and I think that's right. We all have, issues that come up over the course of time. Now, some lawyers, though, especially a defendant's lawyer, oftentimes, I told you, delay is of value. So I'm not just going to continue it because you ask. If you've got personal problems and stuff, that's fine. But just because your client doesn't want this case to resolve quickly, I hear what the lawyer is saying, but there will be some lawyers that will ask, and they just want to delay. And that you've got to be careful as to what the difference is. But obviously, you should be professional, and if someone needs an extension, to grant that extension. But some cases, you're going to find that it's an extension after extension after extension, and they're not requesting in good faith. They're doing it simply to stall the process. He says, and I readily agree, when not ultimately prejudicial to your client, to request by the other party to stipulate to facts. It'd be nice. Not a lot of lawyers don't stipulate to anything. The admissibility of evidence, and again, that's kind of interesting. Many lawyers will. When you know it's admissible and you know they can get it in, what's the big deal with just saying? And by the way, many trials now we have to, before we even get to begin, the court wants a list of exhibits that you all agree to, and a list of the exhibits and the reasons you don't agree to. And so they're going to scrutinize that. So don't, save the important problems for stuff that is important. Don't just argue about everything. And the court, this helps the court speed up the proceedings as well. It's very difficult to get multiple days from a court for trial. So to the extent that we can reduce the trial time, you've got a better chance at actually getting that trial date sooner rather than later. He's got number 3 here. I'm just going to read it, and then you can think about it. It says, refuse to take advantage of mistakes committed by opposing parties and counsel.
What?
Yeah, no.
Well, the lawyer is not a pope. So
Huh?
The lawyer is not a pope. So why?
Well, I hear you, and that's, to me, I think this is very nice as a sort of aspirational, but I'm supposed to help you when you screw up? Because that's not the way that, I can't do that, I won't do that, and I never thought I have any obligation to. Okay, refrain from ad hominem and negative personal, and that you should, or sarcastic comments. Sometimes that gets a little hard, the last part. But you really should, again, you shouldn't do any of those things. I have a problem with sarcastic, because in some cases, because there are some lawyers that is precisely what they... I'm coming off this bad case right now, so I'm not in a good place with some of this, because I'm not, because this lawyer is the worst in 30 plus years of practicing law. And so, there shouldn't be any of that, and there shouldn't be any of that. And here's the point, even when they start, because it's easy to stay up high if the other side's up high. But it's very easy then to roll around in the mud with the other side as well, and that doesn't serve either of you in front of the court. So, this is good, it's more than aspirational, and should take it to heart more often. And trust me, you should be better at it than I probably am. It says, set a peacemaking tone at settlement meetings and court hearings through moments of silence, readings, a discussion of the beauty of the day, or even a prayer.
What?
Yeah, I know, I missed some of that first time around. Okay. This is obviously a little more flowery. This sounds like something you'd hear from Professor Caldas as opposed to Coyne. So, and then let me give you this last one, though, that is important. Listen. Truly listen. And show that the lawyer is listening to the concerns and questions of the other side. Before debating or dismissing such concerns, take a moment to acknowledge in understanding and appreciation that they are willing to share such concerns. I'm not sure I'd say it quite like this author is saying, but if I take the last point, to the extent we're bickering back and forth, and we are trading sarcastic comments and lobbing volleys at each other, that doesn't make for a fruitful dialogue to sit down and really figure out what the value of the case is, because I don't like you, you don't like me, and I'd just as soon screw you. And if I can beat your ass at trial and humiliate you, that's all good to me. But that's not healthy for the case. It's not healthy to promote a discussion and a resolution of the case. And if I really have the client's best interest at heart, I need to listen to the other side. I need to figure out where they're coming from, what their problems are, because if I listen to what their issues are, then I've got an opportunity to address them, and maybe takes a little creativity to reach that solution that we can all live with. But I can't just dismiss it, I've got to listen to it, because well-founded or not, this is hanging up the potential settlement of the matter. And so this is an interesting article. I'm just pointing out some of those things. It's a little too touchy-feely for me. But I hear what he's saying. And what I would add to some of that is maybe despite some of those cases where you've got hard feelings or you dislike of the other lawyer and their client, that you always have to continue to sort of push and have a discussion and try to get to the merits. Because no matter what, we don't have to like each other to reach what would be a good deal for my client. And maybe sometimes I gotta bite my tongue in order to reach what would be an appropriate deal for the client. And that's what I think that they're trying to say, saying it a little more flowery than I think we need to. And the last thing I want to say about mediation and conciliation, mediation especially, or conciliation, doesn't really, not a big difference. First of all, if it's arbitration you have to prepare just like a trial. Because you've got to present a case, and then the arbitrator is going to decide. Arbitration, while it's lumped in with ADR, it's outside of court, so it is alternative to that process. But arbitration is an adjudicated result, just happens to be by a private party. So there's going to be a winner and there's going to be a loser. And especially in arbitration, you have to prepare it just like the case is tried. You've got to know what the rules of evidence are for receiving evidence, how much time you have to provide information, what your rights on examination are. Arbitration have their own rules, but it's going to be an adjudicated result. Okay? Mediation and conciliation are where we try to talk and try to reach a compromise and negotiate a solution to the case. To me, this still, you need to approach as if you were trying the case. Because not from the standpoint of this. preparation, preparation, preparation is what goes into trials. If I'm using a mediation to try and reach a result I need, well, then I better be prepared to argue and provide proof of it, the merits and support of my case, right? Well, I might go into a mediation with my 10 best documents that prove what I say proves liability, and maybe whatever half a dozen significant pieces of evidence that I have that are going to prove damages. And maybe within that I'm going to pull out a few admissions that the defendant or his people have made that help to establish the liability of my case. Now, I'm doing that so that I can show the strength of my case and the value of my case. Because at the end of the day, the mediation is about trying to reach an appropriate number that we can all live with. Well, I know the defendant is going to be telling them stories that aren't necessarily true. They're going to be providing them, if they're doing what they're doing, same type of thing. They're going to say, you don't need to listen to them, look at this, look at that. They're going to have other information. Partly what we do in a mediation is we need to educate the mediator about the strength of our position and give them support then when they go to the other side and say, well, what about this, what about this, what about this? They've got a pretty strong case. So even a mediation, if you think about, well, just a settlement conference. No, it's not just a settlement conference. It's an opportunity for you to educate someone about the strength of your case. And maybe we're not going to settle today. I've walked out of numerous mediations because sometimes you've got to be prepared to say no. But then we could have a deal in a week, 2 weeks, or a month because they wanted to push and know that today wasn't the day. And that I've done that a lot. Because today's not the day, not at these numbers, but they need to know that you're not just in it to make a deal today, you're in it for the long haul and are prepared to move forward and try the case if that's what's necessary. But I need you to start to think about the mediation, though, really as your first part of the process to educate, a neutral, someone who hasn't really seen the case before, about the strength of your case, the value of your case, and be able to convey to the other side, well, maybe they ought to think about whether they really want to try it. This case that we just should have resolved, but we haven't executed an agreement yet, there's no doubt in my mind that at one of the conferences where we were at with the judge, when we were asked to leave the room, that he conveyed to them, that, geez, this isn't probably a case you want to try based on what they've got. And he conveyed the same thing to us as well. You're high. I said, I didn't think my number was high at all. But you got to listen, and I hear that. I hear what he says. So to some extent, that that neutral is assessing the case, and sometimes it's important for your client to hear someone else say, "Oh, that you're not getting $2 million in this case. That's not likely to happen." And so the mediation, no matter what, or the being in front of someone who is removed from the adversarial role, like you are, and your adversary, whoever that lawyer is, to have a fresh set of eyes, that's a good opportunity to try and measure your case and to provide support to that person to help you convince the other side that they should resolve it. So I don't want you to think about mediation and conciliation. I need you to look at those articles because you need to think about it in a slightly different vein than you may presently, because we don't just all hang around in a circle and sing Kumbaya. We've got work to do there. And the fact is that if you do your work properly there, you might come away with a deal that will favor your client and save you and your client lots of time and money with respect to not having to try the case. So we'll talk about some of that as we go forward as well. And the last part of that is one of the articles makes reference to picking the mediator, picking the conciliator is at least as important as the judge you're before. Some mediators are terrific, some have great experience, others aren't worth a dime. My experience, retired judges bring a lot to the table, especially from the client's perspective, and should be yours as well, because if they've got a lot of experience hearing cases and hearing juries come back, then they should have a better handle on what the values are. They also come to the table with a little more of an imprimatur for the clients as to legitimacy. I've had, and there are some commercial companies that both have retired judges or others. Part of it is the strength and experience of the mediator. And there are some terrific people who are not judges that come to the table. But you need to know their background because, again, just as if I'm trying to reach a judge, that I need to know what the arbitrator's hot buttons may be, what the mediator's hot buttons might be, what might help to sway them. So I will see you a week from today, and I'm going to leave some of these for you with the 103 questions, but there's others outside my office. But I would caution you, I don't know whether that'll be ready, the audio will be ready on Thursday. It might be with the PowerPoint. That'll just be a little different than the existing one, and it'll be more up to date as of last semester. So I would wait on that. I'm sure you have other readings you can do for your other classes. But this, hopefully, will get you that audio by the end of the week. If you want to do it with the old audio, you're welcome to it. Okay? I will see you next Monday.